other very important legislation from the perspective of the water pollution is the Environment Protection Act of 1986. This being an Environment Protection Act is more of an umbrella legislation than the Water Act, which is quite specific to water pollution, or the Air Prevention and Control of Pollution Act of 1981, which is specific to air pollution. The objective of the Environment Protection Act is protection and improvement of the environment, and it applies to different types of environmental pollution, including water pollution. In case of conflict between the Environment Protection Act and the provisions of the Water Act, the Environment Protection Act will prevail. One of the important powers which is granted under the Environment Protection Act is the power of the Ministry of Environment and Forests, a central government ministry, to lay down standards for environmental quality in its various aspects and for emission or discharge of environmental pollutants from various sources having regard to their quality or composition. As a result, rules have been laid down for water quality standards for various areas and purposes, and for the maximum allowable limits of concentrations of various water pollutants for different areas under the Environment Protection Act. The Act requires any person carrying on any industry, operation or process from discharging or emitting water pollutants or permitting the discharge or emission in excess of prescribed standards is prohibited. Occurrence or apprehension of discharge of a water pollutant in excess of prescribed standards due to an accident or other unforeseen act or event takes place, the responsible person as well as the person in charge of the place where the discharge occurs or is apprehended is required to take two steps. First, to prevent or mitigate the resulting water pollution, and to inform the prescribed authority about this event. And then the prescribed authority can undertake the necessary remedial measures as early as practicable. Under the Environment Protection Act, the Ministry of Environment and Forests has issued a number of notifications which are relevant for the prevention and control of water pollution. Some of these include the Environmental Impact Assessment Notification of 2006, a whole series of eco-sensitive zone notifications, as well as the Coastal Regulation Zone Notification of 2011. The laws include a number of provisions which are extremely relevant for the control of water pollution, but they have been very poorly implemented, or they have not been implemented at all. Let us now discuss some of the reasons for this state of affairs. The major reason is, of course, the inadequate infrastructure. By that I mean monitoring stations and the frequency of monitoring of water pollution. There is also a low rate of compliance because of poor implementation and monitoring by state pollution control boards, and this is on account of the failure of the SPCB to act against defaulters or polluters due to resource constraints, which include financial resources, human resources and technical resources, the lack of will in some cases to pursue these cases. Corruption in some cases has also affected the implementation of these acts, and also the multiple responsibilities of the state pollution control boards. There is also very low quantum of penalty or fine which is imposed under these laws, as a result of which the cost of non-compliance with these laws is often lower than the cost of compliance, which also does not deter the polluters from causing water pollution. The inadequacy of standards has also been raised as a serious issue, because it is felt that in some cases the standards which have been laid down under the Water Act and the Environment Protection Act are inadequate to address the water pollution concerns. The other issue specifically with the Water Act is that it's confined to point sources of pollution. As you may remember, point sources of pollution are pollution sources such as industries and also pollution resulting from discharge of untreated or partly treated sewage into water bodies. Other cases such as agricultural runoff are not covered by the Water Act, and this has also restricted the scope and implementation of the Water Act. Coming now to some of the important decisions with respect to water pollution, I'd like to clarify that there's a whole range of decisions relating to water pollution, relating to a number of different issues concerning water pollution. However, in this presentation, I would like to highlight 4 decisions of the Supreme Court. The first decision is MC Mehta versus Union of India, a 1988 decision also known as the Kanpur Tanneries case. This is a case where concern was raised about discharge of untreated trade effluents by the tanneries near Kanpur city in the state of Uttar Pradesh into the river Ganga. Now, the Supreme Court made a number of observations in this case. Among them are that the provisions of the Water Act were comprehensive, but the SPCBs had not taken effective steps to prevent the discharge of effluents into the river Ganga, that the central government had failed to do much under the Environment Protection Act to stop the grave public nuisance caused by tanneries, the fact that the effluents from the tanneries were first discharged into municipal sewers did not absolve them from being proceeded against under the provisions of the law in force, since ultimately the effluents did reach the river Ganga. The court ordered the stoppage of work in the tanneries which were discharging effluents into the river and which had not set up primary treatment plants. It considered the financial capacity of the tanneries to set up primary treatment plants to be irrelevant. According to the court, the tanneries had not been taken by surprise, as they had been asked to take the necessary steps to prevent discharge of untreated sewage into the river for several years now. The second case that I would like to discuss is MC Mehta versus Union of India, another 1988 Supreme Court decision which is known as the Kanpur Municipalities case. While the previous case was concerned about the discharge of untreated effluents from the tanneries near Kanpur city, this case was concerned with the discharge of untreated sewage effluents by the municipal authorities in the city of Kanpur. In this case, again, the Supreme Court made a number of interesting observations. The first was that the municipal authorities have the statutory duty to prevent public nuisance caused by pollution of the river Ganga. In this respect, the Supreme Court considered the provisions of the applicable municipal laws in the state, which talk about the responsibility of the municipal authority to prevent and control water pollution. The court also noted that the Municipal Corporation of Kanpur has to bear the major responsibility for river pollution near the city, and it also noted that many of the provisions of the Water Act and the municipal laws for prevention and control of water pollution have just remained on paper without any adequate action being taken pursuant thereto. What we find in both of these decisions, the Kanpur Tanneries case and the Kanpur Municipalities case, is that the Supreme Court is of the view that although the Water Act and the Environment Protection Act include a number of important provisions to control water pollution, the State Pollution Control Board, the Ministry of Environment and Forests in some cases, and the municipal authorities have failed to discharge their responsibilities fully. The third important case that I would like to discuss is Indian Council for Enviro-Legal Action versus Union of India and others, a decision from 1996 Supreme Court. In this case, the water in wells and streams near an industry had become unfit for consumption as a result of disposal of untreated toxic sludge from the premises of the industry. The court observed that the respondent industry was absolutely liable to pay compensation for the harm caused by them to the villagers in the affected area and surrounding areas, as well as to the environment. In this respect, the Supreme Court invoked the polluter pays principle, which has been discussed in detail in the module on principles of environmental law. The court also observed that the power to levy costs required for carrying out remedial measures is implicit in the Environment Protection Act. The last decision that I would like to discuss is Vellore Citizens Welfare Forum versus Union of India and others, another decision from 1996. Now, in this case, water pollution was resulting from the discharge of untreated effluents by tanneries and other industries into a river which was a source of drinking water supply. In this case, the court directed the constitution of an authority under the Environment Protection Act to deal with the situation created by the tanneries and other polluting industries in the state of Tamil Nadu. The court also directed the authority to frame and execute schemes for reversing ecological, environmental damage caused by pollution in the state. It's also important to note that this is another decision in which the Supreme Court invoked the polluter pays principle, which has been discussed in the module on environmental law principles. The court also ordered the imposition of a pollution fine on all the tanneries, and it said that if the tanneries are unable to pay the pollution fine, then they should be closed. Also, it said that the closure orders on tanneries can be suspended where the tanneries agree to set up common effluent treatment plants or CETPs or individual pollution control devices, and they obtain the consent to operate from the State Pollution Control Board. However, in case of failure to obtain such a consent from the SPCB, the tanneries will be closed. Before ending the presentation, I would just like to summarize what we have done today. We have looked at provisions of the Constitution of India that are relevant with respect to water pollution. We have looked at two of the main legislation in India which relate to water pollution, an umbrella legislation, the Environment Protection Act of 1986, and a specific legislation on water pollution, which is the Water Prevention and Control of Pollution Act 1974. Finally, we looked at 4 decisions of the Supreme Court where the courts have 1. Highlighted that the provisions of the laws are comprehensive, 2. That the concerned authorities have not been successful in discharging their functions under these laws, and 3. The court has also invoked certain environmental law principles such as the polluter pays principle in order to impose pollution fine, damages or compensation on the polluter. Thank you very much.